Good morning, everyone, and welcome to Mills Reeve's Cover Talk Plus. My name is Andrew Tobin, and I'm a partner specialising in insurance and reinsurance coverage on behalf of insurers and reinsurers. I'm joined today by David Phillips, Stephen King, Shanice Holder, and Alana Williams from our National Insurance Disputes team. In the next 45 minutes, we'll try to summarise some key points from about 10 recent cases of interest to insurance practitioners. Go up the next slide, please. Which include non-disclosure, misrepresentation, COVID cases, claims notification, conditions precedent, aggregation in a med-mal context, jurisdiction and personal injury, class actions, and data breach. This session is being recorded and slides will be emailed to you afterwards. Please ask any questions in the question and answer box, where my colleague Harriet Strevens will gather them up for us to answer at the end. I'd like to kick things off by mentioning 3 cases on non-disclosure and misrepresentation. In all 3 cases, the courts revisited and restated long-established principles that are still relevant today, notwithstanding the passage of the Insurance Act 2015. So in Ristorante and Zurich, the insured was a leaseholder of a property in Glasgow. When applying for its insurance, the insured had agreed by selecting Agree in a drop-down menu with the following statement shown on the slide. No owner, director, business partner, or family members involved with the business has ever been the subject of a winding up order or company or individual voluntary arrangement with creditors or been placed into administration or receivership. However, Zurich discovered after the fire that all of the directors of the insured had in fact been directors of other businesses that had gone insolvent. And so Zurich sought to avoid the policy for breach of the duty to fairly present the risk under the Insurance Act 2015 on the basis that the insured's statement was untrue. In other words, that it was a material misrepresentation. The insured said that its statement was correct because, properly construed on a literal reading, it asked only about the insolvency events of an owner, director, business partner, etc., and did not, on a literal reading, ask about the insolvency events of other companies those persons may have been connected to. Zurich said that that was the wrong interpretation and that the question or statement should be understood to have been asking, amongst other things, about the director's previous involvement with other businesses that had gone insolvent. And Zurich gave 3 reasons for that. They said it made business sense for it to ask about the involvement of directors with failed companies, that most of the second half of the statement referred only to insolvency events that affected companies, not individuals. You'll see the references there to administration or receivership. And Zurich said that when a company was wound up, then its directors could be said to be the, quote, subjects of, end quote, the insolvency proceedings, which was the language used in the statement. So the court's job was to decide which interpretation was correct. The court reminded itself of case law stating that proposal forms are to be construed by the court objectively, disregarding the subjective intention of the parties. But that if questions asked by insurers are ambiguous, then they should be construed against the insurer. But the court found no ambiguity and agreed with the insured that grammatically, the statement was about the insolvency of the directors and not about the insolvency of any other businesses that they had been involved with. The insured statement made perfect sense on a literal reading, and if Zurich had wanted to ask about the insolvencies of other businesses the directors had been involved with, then it could have done so, but it hadn't. Zurich's backup argument was that the insured was nevertheless obliged to disclose the insolvencies of the other companies the directors had been involved with anyway. But Zurich got nowhere with that because it's well established by the case law that where insurers ask questions on particular matters, where an insurer asks questions on a particular matter, it can be taken to have waived its rights to be told of information on related or kindred matters, which is the wording on the slide from a textbook, McGillivray. So, for example, where an insurer asks about how many accidents a driver has had in 3 years, the implication is that it does not want to know about older accidents. Similarly, by asking about the personal insolvency of the directors, the implication was that insurers did not want to know about the corporate insolvencies of companies the directors had been involved with. So the insured had a comprehensive win. The case is an excellent reminder that questions in proposal forms need to be drafted very carefully. My second case, Berkshire and AXA, is on a similar theme. It concerned construction all risks policy. The renewal quote contained a declaration that neither the policyholder nor its directors had been convicted or charged with a criminal offence. However, it emerged that 3 months before the renewal, one of the directors had in fact been charged in Malaysia in relation to an alleged fraud over there. Now, those charges were completely unrelated to the insured in this case. A claim was made for flood damage and on the property in the UK, and AXA denied liability on the basis that the insured had failed to disclose the criminal charges of one of the directors in Malaysia. So the first question before the court was materiality. Was the allegation of criminality a material fact, even though it was only a material fact that should have been disclosed to underwriters, even though it was only an unproven allegation in another country with no direct connection to the insured project? The policy was subject to the Insurance Act 2015, but nothing in the dispute really turned on that. And the court followed the 2003 Court of Appeal decision in Brotherton that makes clear that even unproven allegations of criminality are usually material facts that must be disclosed to insurers. So AXA succeeded on the question of materiality. But to have a remedy under the Act, or indeed under the old law, AXA also needed to show that it had in fact been induced into entering into the policy on the terms it did because of that non-disclosure, the so-called inducement test or hurdle. In fact, it was easy for AXA to do so because it was able to produce to the court an internal underwriting guideline memo that made clear that the risk should be declined if allegations of criminality had been disclosed. So the court gave judgment for AXA. And I think this case highlights 2 points. Firstly, it's a reminder that mere allegations of criminality against an insured or directors can be material facts to be disclosed, even if they're unproven. Secondly, that insurers' internal documentation can be relevant in proving inducement. Now, both of these are well-established principles, but I think we'll see insurers' internal underwriting guidelines assuming more importance in cases over time, because the Insurance Act now links the type of remedy available to insurers to the actual likely effect of the non-disclosure or misrepresentation on the underwriting decision. And internal guidelines may be relevant in showing precisely what the underwriters would have done in terms of declining the risk, charging extra premium, or underwriting on different terms. My third case, Zurich and Miramax, is a Court of Appeal case. Zurich had issued a mobile plant policy to Miramax. Miramax had not disclosed to Zurich that its property insurer had applied special terms to the property policy because a recommended fire suppression system had not yet been installed. That property burnt down along with the insured mobile plant, leading to a claim against Zurich. Zurich sought to avoid the policy for the non-disclosures. It was agreed by the parties that the non-disclosed information was material, but the main issue in the case was whether Zurich had been induced to write the policy in the way it did, i.e. with a very low premium, by that non-disclosure, in circumstances where the evidence showed that the cheap rate had been wrongly applied by a junior underwriter by mistake. Zurich's response was that, but for the non-disclosure, the junior underwriter would have referred the risk to a senior underwriter who would not have underwritten the policy. And so there was a clear chain of causation, in fact, between the non-disclosure and the eventual underwriting decision. They were saying that but for A, B would not have happened. Therefore, the cause of B must have been A. That's the so-called but for test. The court looked at the law of causation in relation to questions of inducement, as well as comments made by the Supreme Court on causation in the FCA COVID case, and rejected Zurich's but for causation approach, saying that in order for I'm quoting from the judgment, in order for non-disclosure to induce an underwriter to write the insurance on less onerous terms than would have been imposed if disclosure had been made, the non-disclosure must have been the efficient cause of the difference in terms. If that test of causation is not fulfilled, it is not sufficient merely to establish that the less onerous terms would not have been imposed but for the non-disclosure. And on the facts, the court concluded the sole efficient or effective cause of those particular terms being offered by Zurich was the junior underwriter's mistakes and not the non-disclosed information. The non-disclosure simply gave the underwriter the opportunity to make the mistake, but it was her mistake, nevertheless, that led to the low rate. And so judgment was given in favour of the insured. The case is a useful reminder that inducement to enter a policy in a particular way or at all cannot always be assumed to flow automatically from a non-disclosure or misrepresentation. Rather, insurers need to be able to persuade the court of an effective real link between that and the underwriting judgments that were actually made. That concludes my part of the presentation. I'd like to hand over to David.
Thank you, Andrew. My name's David Phillips. I'm a principal associate in the insurance team, and today I'm going to give you a quick overview of 3 recent COVID-related business interruption cases, being Rockwell and Travellers, TCK London Allianz, and I'm also briefly going to discuss the FCA test case against a number of insurers, which was decided by the Supreme Court. For anyone that doesn't know, in broad terms, business interruption insurance provides cover for loss of income when a business is prevented from carrying out its business as usual due to some unexpected events. Now, Rockwell and Travellers was a High Court decision. It concerned a policy which provided cover for losses caused by a list of infectious diseases. The diseases in this instance were split into 3 sections, and cover was triggered by the disease either manifesting itself in a person at the premises, which led to its closure, or an outbreak of one of the specified diseases within 10 miles of the business premises. Now, the inclusion of food or drink poisoning is a bit of an outlier because it's not an infectious disease in the ordinary sense of the word. And the second and third lists in the policy originated from the definitions of notifiable diseases in various bits of public health legislation. Now, importantly, as you can see, the definition says what infectious diseases mean. In other words, it's a closed list and not qualified by words such as includes or, for example. And the list does not include COVID-19, SARS, or influenza. Now, Rockwell argued that the inclusion of the word plague should be read as the inclusion of any infectious disease with a high mortality rate, becoming an either epidemic or a pandemic. It also argued that some of the diseases on the list could be caused by COVID-19, with the result that those listed diseases should include COVID-19. Travellers disagreed and successfully applied to have the claim struck out. The court agreed that the intention of the definition of infectious diseases was to create an exhaustive list. The court then applied the reasonable person test, that is, the test that what would a reasonable person think the policy was intended to cover, to consider the argument that the inclusion of the word plague was to include an epidemic with a high death rate. The court concluded that such an interpretation was in effect a Lloyd's construct, and that an ordinary reader would consider the reference to plague to be to the specific form of infectious disease known as plague and caused by the plague bacteria. The court also rejected the argument that just because COVID-19 may cause some other diseases on the list, it was therefore also covered. He said that it couldn't be argued that the resort came to be closed for such a long period of time because of an outbreak of, say, food poisoning, even if it's accepted that COVID-19 may well lead to digestive symptoms. The next case I'm going to discuss is TCK London Allianz. This was another strikeout case in the High Court. TKC is a cafe, and they claimed about £5,000 worth of loss for deteriorated stock. Now, their policy contained a section entitled business interruption, and that indemnified business interruption by any event. Business interruption was defined as loss resulting from interruption or interference with the business in consequence of an event to property used by the insured, and an event was defined as an accidental loss or destruction of or damage to property used by the insured. Now, the court said that the use of the word by meant that the interruption had to be as a result of an event to property used by TKC. Now here, as a matter of fact, the deterioration of the stock during the lockdown closure did not cause the interruption to the business because the business was already closed down as a result of the lockdown. So in practical terms, it was the lockdown which caused the deterioration of the stock and not the other way around. Further, the court said that the deterioration of the stock could not be interpreted as accidental, as that phrase could not include the natural process of decay of perishable items. So for those reasons, that case was also struck out. Turning now to the FCA Supreme Court decision. Now, we've actually got two specific cover talk sessions dealing both with the High Court and the Supreme Court decisions, and they are available on our website. I'm only going to deal with a certain aspect of it, and I'm going to briefly compare it to the outcomes in the two cases I just discussed, in particular Rockwell Hall. So the FCA test case dealt with notifiable disease wordings. They cover losses arising from a notifiable disease arising within a certain radius of business. And a notifiable disease is one which is required to be reported to the public health authorities. COVID-19 became a notifiable disease on the 5th of March 2020, so fell within the scope of cover. Now, insurers had argued that the occurrence of the insured peril, so that is occurrences of COVID-19 within the radius of the business, must have caused the claimed business interruption loss, but they did not, because the lockdown would have been ordered by the government in any event. Now, the court rejected that argument, overturning previous authority. The court said that it could not have been the commercial intention of the parties that uninsured cases of COVID-19, by that they meant cases of COVID-19 that occurred outside the radius of cover, should deprive the insured of an indemnity for interruption also caused by the same disease, i.e. COVID-19. I think it's interesting when you look at the outcomes in Rockwell and the FCA case, and to a certain extent TKC as well, because it seems hard to imagine that Rockwell would have gone through the list of the 35 specified diseases in their wording and decided that those were the diseases they were concerned about, and they were not concerned about any new diseases of unknown origin arising. Or alternatively, that they looked and said that they wanted food and drink poisoning, and also those notifiable diseases which were already known about and referenced in public health legislation. So there's the commercial intention, or most likely both of those insureds, those who have the wording that dealt with by the FCA test, and those who may well have what were known as specified list wording, would have been very similar, I believe, to have cover for the type of interruption that was caused by COVID-19. However, it's hard to argue against the notion that the intention of an insurer, which provides a list of covered diseases, intends to cover only those diseases. That is their commercial intention. I think there's always a concern where you have cases where there's a stark difference in outcome between different insureds due to specific policy wordings, particularly where they may not have properly understood or considered those wordings in any detail. Here you have a scenario where some classes of insureds with specified list wordings will not have cover, whereas those who have notifiable list wordings may well have cover. And I think there's always a risk in those circumstances that those insureds which are not able to recover their losses may look to their broker to potentially recover their losses through their E&O cover. And on that cheery note, I'm going to pass you over to Shanice.
Thank you, David. I'm Shanice Holder, an associate in the insurance disputes team here at Mills Reeve. I will be looking at the importance of notification provisions highlighted by the case of Arch Insurance UK Limited and McCullough. As some of you may know, this case concerns an incident involving a young girl injured at a motorbike track. The insured was the owner of the motorbike track. He failed to notify the incident to insurers under a liability policy with a delay of 11 months. This case is a good example of the importance of condition precedents and how they are still to be applied. To be clear, a condition precedent is a term in a contract which provides that the agreement or certain parts of the agreement will only come into force if and when those certain conditions are satisfied. The facts were thus. On the 26th of October 2019, a young girl fell from her bike whilst riding around the motorbike track. She sustained serious brain injuries and multiple fractures. The defendant was present at the track at the time of the accident. He kept in contact with the child's parents throughout the incident and following, and it was common knowledge on the circuit that no one held him responsible for the accident. However, on the 9th of June 2020, a letter of claim was sent to the defendant alleging that the accident was caused by the dangerous condition of the track. A claim form followed in September and was served on the insured. 11 months after the accident, on the 15th of September 2020, the defendant's broker notified the claimant insurer of the circumstances of the accident and made a claim under the policy. There was a condition in the insured's policy which required the insured, as a condition to any liability, to give written notice as soon as reasonably practicable of any circumstances which may have given rise to a claim being made against him. This clause operated as a condition precedent to the insurer's liability. As a result of the delay, the claimant insurer applied to court for a declaration that it was not obliged to indemnify the defendant under the terms of the insurance policy. Insurers argued that condition 3 was a condition precedent to liability, and this had not been complied with. It was therefore entitled to deny liability for the claim. Against that backdrop, the application was granted. There are a number of observations to note. The judge applied an objective test and took into account the defendant's knowledge of the occurrence or circumstance which might have given rise to an indemnity. The judge stated that a reasonable man would have realised that the risk of a claim as a result of the accident was not fanciful, it was realistic, and therefore there was an obligation upon the insured to notify the insurers. The defendant had been aware of the accident promptly, as he was present, and had subsequently kept in touch with the child and her family. He had carried out his own investigation and had been unable to identify the cause of the accident. However, the reassurances that he had received from the family stating they did not hold him responsible had been informal. There had been nothing in writing to support the verbal assurances. They were in effect irrelevant. The fact that the defendant had carried out the investigation and sought reassurances was indicative of the fact that in reality, he understood that the accident had been serious and there was a real risk of a claim. He should have notified insurers at the time of the accident or shortly thereafter. In any event, he knew of the claim in June 2020 when the letter of claim was received. The requirement to notify the claimant as soon as reasonably practicable had not been complied with. The purpose of the condition was to allow the claimant to investigate the claim. As a result of the delay, there were certain investigations they could no longer carry out. Condition 3, as is shown on the slide, along with condition 1, was a condition precedent to liability. The condition was workable in ambit and had a clear commercial purpose, namely to allow an insurer to investigate in a timely way. A declaration of non-liability was therefore appropriate. It is worth noting that this decision is post the enactment of the Insurance Act 2015. I'll turn to considering the implications of this case for policyholders. It is crucial that policyholders are aware of the notification provisions in their policies when their obligations to notify are triggered, particularly where the obligation falls under the operation of a condition precedent to the insurer's liability. Many insureds are not insurance aficionados. They reasonably apply common sense rather than expertise when it comes to notification, but this is unlikely to comply with the policy, and it is therefore essential that insureds are aware of circumstances that will trigger their obligation to notify. If the notification provisions are not complied with, this can lead to a claim being declined due to non-compliance with the policy. Policyholders should ensure they are familiar with the timings and mechanisms for notifying a circumstance or a claim to ensure they do not prejudice insurers and/or themselves. Open communication is therefore of paramount importance, and insured should endeavour to be as transparent as possible when keeping insurers updated. If insureds are ever unclear about whether they should notify a circumstance, it is better to do so. Insureds need to be mindful of whether there is a real risk of a claim being brought or it is merely fanciful. However, reassurances from a potential claimant are not enough to conclude a claim would not be made, and the insured should itself consider whether there is a real risk in such a scenario. From insurers' perspective, it is also important for insurers to clearly communicate whether a notification condition is a condition precedent, and they should use clear policy wording that is easily understandable. This case does not make new law. What it does do is illustrate that English law continues to robustly uphold the strength of the condition precedent. Failure to notify on time means the insured risks no cover. It is encouraging to know that the condition precedent remains alive and well. I will now pass over to Stephen.
Thank you, Shanice. Good morning. I'm Stephen King, a partner in the insurance group with a focus on healthcare risks. Today, I'm going to cover two cases. The first is a Court of Appeal decision last month on the interpretation of an aggregation clause in a policy. The second is a Supreme Court decision last year on whether direct damage in a jurisdiction is required in order to bring a case within the jurisdictional gateway in the CPR. So we'll look at the Spire Healthcare Limited case. Royal and Sun Alliance, or RSA, wrote a combined liability policy for Spire Healthcare. Following the negligent and criminal activity of a rogue surgeon, Ian Patterson, a settlement fund was agreed to compensate his victims, with Spire contributing £27 million and them then seeking indemnity under the policy. Patterson's misconduct centred around 750 claims brought by patients who'd undergone surgery for breast cancer, which together Spire called Group 1 and Group 2 claims. Group 1 claims were said to arise from negligence and Group 2 from dishonesty. The criminal elements of Patterson's activity, which earned him a 20-year prison sentence, led his indemnity organisation declining cover. The claimants then sought redress from other deep pockets, and Spire became vulnerable to allegations that it had negligently allowed an incompetent surgeon to operate on patients attending their hospitals. RSA didn't dispute its liability to indemnify, but there was an issue over aggregation. The policy contained a 10 million limit of indemnity. The key wording of the policy was to aggregate all claims during any period of insurance consequent on or attributable to one source or original cause. And Spire claimed it was entitled to two limits of indemnity, a total of 20 million, on the basis that there were two distinct groups of claims. RSA argued this was a false distinction, as all the claims arose from one cause, Patterson's conduct, and that there was a single aggregating factor limiting Spire's claim to £10 million. At first instance, the court found in favour of Spire and allowed that the two groups could be considered two distinct causes. While the aggregation clause applied within those two groups, it didn't apply between them. And the judge referred to the case of Cox and Bankside Members Agency Limited in maintaining his decision. He felt that the motivations of Patterson's were a distinguishing feature in the origin of the causes. RSA successfully appealed that decision. The Court of Appeal held that, contrary to what the first instance judge thought, there was only one source or original cause, and that was Patterson's conduct. Patterson's motivations were irrelevant to the question of Spire's liability and couldn't be used as a basis to separate the causes. So the Court of Appeal set out the relevant principles of aggregation and provided some clarity on the wording. Among other points, Lady Justice Andrews drew on the following four matters. First, aggregation wording should be interpreted in a balanced way. Second, a cause is not the same as an event and can be considered in the widest sense. Third, original cause doesn't mean proximate cause. Although there does need to be a causal link between the cause and the loss, it's not as narrow as proximate cause. Fourth, there's no meaningful distinction between one source and original cause as per the policy wording. So the Court of Appeal overturned the first instance decision, finding that His Honour Judge Pelling QC had misapplied the facts of Cox and Bankside, and that the court should have been looking for a unifying factor in the claim, and consequently all the claims in Group 1 and Group 2 could be aggregated, and there was a single £10 million limit applied. So we've got some clarity on the effects of aggregation clause wordings that use one source or original cause. This wording will aggregate claims on a wide basis, and the court said there should be a broad search for a unifying factor. The second case, this time a Supreme Court case from last year, is the Nile Plaza and Brownlee case, which was handed down in October 2021. And this concerned two issues. One was a jurisdictional gateway issue, the other a foreign law issue. The most important point to note is the Supreme Court's wide interpretation of the term damage sustained within the jurisdiction in respect of the type and severity of damage required to allow a claim in tort to pass through the relevant jurisdictional gateway in the Civil Procedure Rules, Practice Direction 6B 3.1. This ongoing litigation arose from a fatal accident during a holiday in Egypt in January 2010. An excursion into the desert that Lady Brownlee had booked through the Four Seasons Hotel in Cairo ended in a crash, tragically killing her husband and his daughter and seriously injuring Lady Brownlee and her husband's grandchildren. The legal proceedings seeking damages for injuries on behalf of her late husband's estate and for bereavement and loss of dependency were issued in England in December 2012. The litigation ebbed and flowed, but in October 2019, it was ordered, among other things, that FS Cairo be added as a defendant. And as they were based in Egypt, Lady Brownlee needed permission to serve proceedings outside the jurisdiction. In order to gain that, she had to show, firstly, that the claim fell within a jurisdictional gateway under the Civil Procedure Rules. Secondly, that the claim had a reasonable chance of success. And thirdly, that England and Wales was the proper place to bring the claim. The High Court decided she'd met all elements of the test and granted permission. And in July 2020, the Court of Appeal affirmed that decision. FS Cairo then appealed to the Supreme Court. And there were two issues before the Supreme Court. First, whether Lady Brownlee's claim in tort was sufficient to establish that the relevant jurisdictional gateway was satisfied, the tort gateway test. Second, whether Lady Brownlee had established that her claims had a reasonable prospect of success, and specifically, whether she had to adduce evidence of Egyptian law in order to do that. That was the foreign law issue. On the first of those, the tort gateway issue, Lady Brownlee was successful. The court held that in order for a claim to pass through the jurisdictional gateway, it's necessary for some significant damage to have been sustained in England or Wales. Lord Lloyd Jones saw FS Cairo's argument that damage should be restricted to the direct damage suffered and not to the financial or physical consequences of that damage as unduly restrictive. He concluded that whilst the direct damage, the injuries and deaths, occurred in Egypt, the indirect damage, pain, suffering, and financial implications were continuously first felt in Egypt and then in England. On the second issue, that of foreign law, FS Cairo argued that Lady Brownlee had to adduce evidence of Egyptian law to show that her claims had a reasonable prospect of success. She submitted that in the absence of any evidence of relevant Egyptian law, the court should apply English law. Well, the Supreme Court found for Lady Brownlee, but they applied a different test. They applied the presumption of similarity test, and that is that in the absence of any evidence as to what the Egyptian law is, it will be assumed to be similar to English law on the relevant issue. So a couple of observations on that decision. Since Brexit, litigation lawyers have been waiting for guidance concerning claims being issued out of the jurisdiction. And this decision brings some post-Brexit clarity to the framework, the tort gateway, and what types of damage will satisfy the requirements. What remains unclear outside the context of injury cases is the level of damage required to allow a claim to pass through the gateway. Despite that, This is likely to be a welcome decision for claimants, less so perhaps for insurers, enabling claimants to issue in this jurisdiction against foreign defendants for accidents occurring in foreign jurisdictions, with confidence that the tort gateway has been interpreted widely enough to capture the subsequent indirect damage suffered in England and Wales. So that's me done. I'll hand you over to Alana Williams.
Thank you, Stephen. I'm Alana Williams, a senior associate in the insurance disputes team. The case of Lloyd and Google, which I want to speak about today, is not an insurance case per se. However, the decision, which was handed down by the Supreme Court in November 2021, will be of interest to data controllers and their insurers. Why? Because it's likely to significantly curb some of the momentum that had been building around the potential scope for opt-out claims in data breach cases. By way of a quick summary of the facts, the case arose out of the alleged use by Google of a so-called Safari workaround. This was a technical workaround used to bypass the cookie settings on the Safari browser on iPhones and to place tracking cookies without an individual's knowledge or consent. Mr. Lloyd, a consumer rights activist, launched a representative action against Google. He claimed that Google had breached the duties it owed to more than 4 million iPhone users in the UK in its role as a data controller under the Data Protection Act 1998. Representative actions are a form of opt-out litigation. The claim is made on behalf of everyone who is a member of a particular class, unless they opt out. This contrasts with a group litigation order, which is an opt-in regime, requiring individual claimants to decide to become parties to the litigation. Importantly, CPR Rule 19.6 only allows representative actions if each class member has the same interest in the claim. The purpose of this is to ensure that the representative can be relied on to effectively promote and protect the interests of each member of the class. To get over this same interest hurdle, Lloyd argued that compensation could be awarded under the old DPA for a mere loss of control of personal data. He said there was no need to prove that the claimant suffered any financial loss or mental distress as a result of the breach. Lloyd further argued that a uniform sum of damages could be awarded in relation to each person whose data protection rights had been infringed. He claimed that there was no need to investigate any circumstances particular to the individual cases. The sum of damages recoverable was to be a matter for argument. However, Lloyd had raised in a letter of claim a figure of £750 per claimant, multiplied by the 4 million odd iPhone users Lloyd claimed to represent. This would have produced an award of damages in the order of £3 billion. As to what happened ahead of the case proceeding to the Supreme Court, in order to proceed with his claim in the English courts, Lloyd needed permission to serve his claim out of the jurisdiction on Google in the US. At first instance, the High Court refused permission, finding that Lloyd had not presented a good arguable case that Google's breaches constituted damage as defined under Section 13 of the old DPA. On appeal, the Court of Appeal reversed this decision. It found that damages are, in principle, capable of being awarded for loss of control, even if this loss of control of the data did not cause financial loss or mental distress. It also held that since any damages would be reduced to the lowest common denominator, the represented parties did not or did have the same interest in the relevant sense here. Google appealed that decision. The Supreme Court, the decision with which we are concerned, unanimously allowed the appeal in Google's favour. The Supreme Court addressed two questions in its judgment. Firstly, could compensation for loss of control of data be awarded under the old DPA without proof of damage or distress? Secondly, the court considered whether a representative action was a suitable vehicle for data breach claims such as these. On the first issue, the court held that loss of control without damage was insufficient. It found that the claimant must suffer damage as a consequence of the infringement. Damage, as defined in Section 13 of the old DPA, was held to mean material damage, such as financial loss or mental distress. As to whether such a claim for data breaches could be brought as a representative action, the Supreme Court held that the procedure was not suitable for such claims. The difficulty here was that the effect of the Safari workaround was not uniform across the represented class. The court held that even if liability were established, it would be necessary to look at the extent and the impact of the unlawful data processing in each individual case to decide the awards of compensation. It was because of this need for proof of individual circumstances that the court held that the same interest hurdle in CPR 19.6 could not be met. Interestingly, when considering the requirement that all represented parties have the same interest, the Supreme Court commented that this test does not require each claimant to have identical claims or interests. Instead, the requirement is that the representative's interests do not conflict with others in the case. Providing there is no conflict, the court held that there is no reason in principle why all should not be represented by the same person. Alternatively, if there are two groups of people in relation to whom different issues arise, even though there is no conflict of interest between them, the court commented that any procedural objection could be overcome by bringing two or more representative actions, each with a representative claimant or defendant. The representative actions could then be consolidated. In terms of the wider implications of this decision, the claim here was brought under the old DPA 1998, which has since been replaced with the new Data Protection Act 2018 and the UK GDPR. As such, there may still be scope for representative actions to be pursued in relation to claims under the new legislation. Nevertheless, I expect the Supreme Court's comments will have an impact on the availability of representative actions generally. That said, although the decision curtails the availability of some actions, the Supreme Court didn't close the door on representative actions entirely. The court suggested that it would have been prepared to entertain a bifurcated or two-stage approach. This would involve an initial representative action on the question of liability and whether damage had been caused. Individual claimants would then need to bring new proceedings off the back of the first action to pursue damages for the financial loss or damage they had suffered. Such a bifurcated approach could, in effect, introduce a halfway house between a fully opt-out and opt-in procedure. Indeed, the Supreme Court commented that an initial opt-out representative claim would be sufficient to stop the limitation period running for subsequent members of the represented class to bring individual or group damages claims. The court also indicated that representative actions could be used where the damages sought are uniform across the class of claimants. In relation to the court's comments, which arguably widen the same interest requirement, it is likely to be costly and complicated for claimants in most data protection claims to prove that there is no conflict of interest. For example, even if a database holding identical classes of information for, say, 1,000 individuals was compromised, it doesn't follow that each individual would suffer the same harm. Distress is inherently subjective. To conclude, the key takeaway from this case is that no damages are available without proof of damage. Not every data breach or unlawful processing of personal data is capable of giving rise to compensation. The Supreme Court has made it clear that representative actions are permissible, however, even in damages claims, provided they can be properly articulated and managed. It looks likely we can therefore expect more activity like this in the future, particularly in cases where losses are consistent among members of the affected class. Thank you. I'll pass now to our colleague Harriet Strevens, who will address some of the questions which have come in.
Thank you very much indeed. We have a little time for questions, and if I might start with you, Andrew. The question being, what relevance, if any, did the Insurance Act 2015 have on the 3 cases that you mentioned? I think you're on mute, Andrew.
Thank you. And thank you for the question. 2 of the cases were subject to the Insurance Act, and 1 of them wasn't. But that didn't make a lot of practical difference to the outcome of those 2 cases. So, for example, in Restaurante and Zurich, the first point before the court was really the construction of the restaurant answer in a proposal form. What they meant by that, and the Insurance Act hadn't changed the laws of construction and proposal forms, and so the old law remained relevant on that point, which was before the court. The second point was concerned waiver, whether insurers waive the requirement to be told of certain information by dint of asking specific questions. And again, nothing in the Insurance Act changed the previous law on that. The second case, Berkshire, concerned non-disclosure of criminal charges. And the question was about materiality. The new Act has more or less photocopied the key concepts of non-disclosure and misrepresentation from the old law into the new law. So those concepts remain unchanged, and the old law, shedding light on what those concepts mean, is going to remain highly relevant in future. So in short, those cases concern parts of insurance law that have basically remained unchanged by the Act, and we still don't have many, well, really any new cases or any cases on the Insurance Act that shed light on the new aspects of it, such as choice of remedies or the effect of warranties and so on.
Thank you, Andrew. Coming back to you, Stephen, if I may, on the Spire case, the question being asked is, as the surgeon Patterson was self-employed in relation to his practice at Spire, what was the risk of a liability finding against Spire?
Good question. So the real risk was around the direct duties of care that Spire might be said to owe. So being found directly liable for having allowed an incompetent surgeon to operate on patients attending their premises. Also, Spire, along with Heart of England Trust, which was also a unit where Patterson operated, had brought in an independent organisation to review what had been going on, Verita, and the Verita report had found failings similar to those found by the Kennedy inquiry into the NHS bodies, that the governance was lacking. So there was a risk around a direct liability. There were also some potential concerns around vicarious liability, and although there's no ruling on that, this is an area where we may see some development, because even where you have self-employed doctors operating at the premises of independent units, if the activities of the surgeon are so entwined or linked to the business goals of the independent hospitals concerned, then a court might well hang its hat on a vicarious liability finding if there's an issue over the indemnity that the surgeon has advantage of. And of course, in Patterson, Patterson was declined indemnity. So you could see, depending on the facts of a case, both direct liability and vicarious liability might have a part to play, but the direct liability certainly had a part to play in the vulnerability of Spire.
Thank you, Stephen. And very briefly, if I may, whilst you have the floor, in relation to the Brownlee case, does this decision impact in relation to the enforceability of a judgment out of the jurisdiction?
A claimant now has the ability to bring claims in this jurisdiction against foreign defendants, but where they're successful, enforcement is probably always going to be an issue. And it's widely recognised that it's challenging to enforce a judgment of an English court in foreign jurisdictions, particularly those that adopt a civil law system as opposed to common law.
Thank you very much. Well, we're running out of time, and in keeping with our usual aim to finish on time, I'm going to hand the baton back to Andrew on the basis that any outstanding questions can be dealt with by email. Andrew. You're on mute again, Andrew, if I may say so.
Sorry, just stop muting myself. So thank you, everyone. That concludes our presentation today. Please do contact any of us directly with any further questions. Slides and a link to the video will be sent out afterwards. Also, please remember that our entire Cover Talk archive is available online, including detailed ones on the COVID BI case. We probably have 40 or so now of those. Just Google Mills and Reeve Cover Talk. Our next session will be in March. The topic is to be decided. Please do fill in our feedback form and let us have any suggestions. Thank you all very much for your time and attention.